And we're live. Ladies and gentlemen, welcome to our webinar about software development contracts, software development contract standards, I should say, that's the key point, brought to you by STX Next and DSK Legal. With me here today are Michał and Paweł, who are our contract experts and who will be answering my questions today. So first of all, just so I can be sure that everybody can hear us and see us, if you could write a message on the chat that you can see us without any problem and that you can hear us, that would be swell. Michał, Paweł, how are you doing today?
Really fine, thank you.
Thank you, Kuba, nice to see you. Nice
to see you too. Okay, we've got our first message and I think everything is fine. So let's move on to, presenting who will be speaking to you today and answering your questions today. So, as I mentioned, with us today are Michał Jackowski and Paweł Dudko, and I'll allow them to introduce themselves, starting with Michał, perhaps.
Hi, I'm an IT lawyer. I'm also a professor of law, but mostly I'm practitioner. I'm general counsel and legal counsel in over 20 software companies from Poland and from Europe, but I was also advising bigger companies in purchasing software. So today I'm going to share not only knowledge, but also my experience in legal services, both for suppliers and buyers.
Okay, Paweł?
Hello, my name is Paweł. I'm a lawyer and I deal with software development contracts on a regular basis. I also cooperate with law firms in topics like private equity and corporate governance.
Excellent. As for me, my name is Jakub. I work in marketing at STX Next as a team lead. You don't need to know much about me. I'll just be asking the questions and trying to get the knowledge out of the gentleman here. As for what we're going to present today, let me get right to that. Here's our agenda. We'll be talking about contract standards. Why this topic and why now? Because, and I know this is a cliche at this point, but we are living in uncertain times, and in those times, it's good to have your back covered when it comes to when it comes to software development contracts. Standards are the tool that allow you to really stay secure and to minimize risk when it comes to signing these contracts. So we'll talk about the importance of standards. We'll talk about the areas that you should pay attention to in this field. We'll talk about fixed price and time and materials contracts, IP ownership, terms of payment, and concluding contracts, as well as some additional bits and pieces that you should know to basically make decisions for your software projects. At the end, we're going to have a Q&A session. I encourage you to ask questions during the webinar. You can feel free to use the chat and ask questions, and we'll be answering them at the end, but we'll be collecting them throughout the webinar. And that's that. That's the agenda for today. And we can move right on to the first question, which is about the importance of this topic. So why are contract standards important during times of crisis?
Maybe let me start. I could repeat a lot what you said, Kuba, that we all experience now unknown and crisis. And making good, fast decisions is challenging in all circumstances, but it's really crucial right now. The typical approach of many companies would be far too slow to keep up in such turbulence as COVID pandemic, and postponing decisions to wait for more information might make sense during the business as usual. But now when the environment is so uncertain, waiting is a decision in itself. So to know the standard, you need more knowledge, more data, to take fast decisions right now. So we want to share our experience about the standards to enable you to decide faster, not to lose so much time for negotiations before the conclusion of the contract, but also during the performance of the contract.
Okay, Paweł, anything to add?
To be honest, I'm not a big fan of the word crisis, especially in the business area. Of course, we need to be aware of the danger arising from the COVID-19 pandemic and its impact on the economic capacity of companies. But in terms of dealing with software development contracts, I consider the current situation as, let's say, at least manageable. Knowing the contract standards is the necessary background knowledge to tackle the big bets, which was said by Michał, but you need to know the standards to better understand your current position in this challenging time. Maybe you're going to face the necessity to accept some offer that you don't like, but you just need to. Or maybe your business partner will surprise you with some Godfather proposal. Or maybe you have already experienced both. The thing is that we are all experiencing the unknown, and this is not some theoretical talking. I get a strong feedback nowadays from the managers that I'm working with that the clauses in contracts that until now have been treated as unacceptable right now are heavily considered. So let me say that the red flags of the contracts are not so red anymore. So in my opinion, this webinar is a great opportunity to talk about it, and I would like to share with you my knowledge and experience and show you some legal options or happy mediums while dealing with software development contracts.
Right. The red flags are not so red anymore. And it is a new, well, it may be a crisis in some industries. For others, it's just a situation or the situation, I suppose. But indeed, waiting is it is a decision in itself. So contract standards can really help limit that. Very well then. So let's say I'm a tech manager and I want to get some work done. I've decided to work with a vendor and I'm presented with a contract, maybe a first draft of the contract. What should I pay attention to? What are the general areas that I should pay attention to when I'm looking at my software development contract?
When it comes to me, and I don't have much time to review the contract, I usually start the revision by checking the liability clause. So this is the first area that comes to my mind here. And I can tell, basing on my experience, that this clause is one of the most common costs that terminates negotiations. Liability clause is a contract provision in which the parties stipulate their obligation to indemnify the other party in specified cases, mostly when the other party suffers a damage. So parties may be really creative here and often proposing one-sided solutions that protect their business. Please remember, it needs to be done to the extent permitted by law. Giving you one basic example, let's say you have a software development contract in your hands. I suggest you should start with finding out how the scope of liability is determined. In other words, what does exactly indemnification of the damage covers? There are mainly two options here, and indemnification of the damage may cover only the losses which the aggrieved party has suffered, or also it may cover the benefits which the aggrieved party could have obtained. So you see there is direct and indirect damage, and I hope you see the difference, but the thing is that you should be aware that it should be precisely determined in the contract. Otherwise, if not, you should expect that the governing law of the contract shall apply. I'm okay with the losses, and I have a few reasons to think so, and to give up the benefits during the negotiations in order to gain a stronger position on another more important topics. And the second area I would like you to be aware of is intellectual property transfer clause. This is a contract provision in which the parties stipulate the rules of transferring the copyrights of the real product of their cooperation, the software. So this is a real deal. This is the main point of their future cooperation. This is why they met and would like to conclude a software development contract. You need to understand the rules of transferring the copyrights in order to understand when you're the owner of this product and why is it so important. So for me, maybe these two areas, maybe Michał would say something more from himself.
Thank you, Paweł. I would add that we lawyers tend to review liability, indemnification, insurance, warranty, and other, let's say, legal clauses, but we often forget about the process itself. We tend to leave the scope to the contract to CTOs or project managers, and it ends with very general and open clauses or with very detailed but unrealistic waterfall specifications. Both solutions are, in my opinion, wrong, because when you have very general clause, it's not easy to inspect, to review, to take over. When you have very detailed specification, very often it has to change during the performance of the contract. So most important for me are the clauses of the scope and the process itself, either waterfall or agile, and what's also very important, the exit from the process itself. So the proper agreement flow ensures you to get best fitting technological framework, it allows you to get the product, proper products, proper scalable product. So this is what I really take care for.
Okay, so take a look at IP ownership, take a look at liability, but also pay attention to the process itself. And in terms of, for example, IP ownership, we'll be getting into more detail on that in just a second. But now, another thing to consider, and I think something that tech managers are very familiar with, or some of them definitely will be, are fixed price contracts versus time and materials contracts. I've heard various opinions about which one is better for which side of the contract. So in these times, when the most important thing is to minimize risk, which one of these do you think would be preferable, or what are the trade-offs of going with either fixed price or time and materials?
Maybe let me go on with the process and describing the process. I would start from presenting project methodologies that are linked with IT contracts. I see two main methodologies. There are either waterfall projects where you have a clear vision of the project, its detailed scope, schedule, and have even quite precise documentation, and you know for sure how much you want to pay for it. And there are agile projects where you have a very general view of expected solutions, very general time frame, and possibly very general view on the budget. Sometimes it's just a cap you want to pay to spend. And of course, there are plenty of projects that are hybrids of these two models. These types of projects require different types of IT contracts because you have different KPIs, different flow of project, different type of leadership and project management. So legal contracts also fall into broad families. There are either fixed price contracts or cost reimbursable contracts. And there is a third hybrid type commonly in use that it's called time and materials contract. So starting from fixed price contracts, they involve setting a fixed total price for a defined product, service, or result. What's worth mentioning, fixed price contracts do not need to be a firm fixed price, but may also incorporate financial incentives for achieving or exceeding selected project objectives, such as scheduled delivery dates, costs, technical performances, or anything that can be measured. Such the contracts are called fixed price incentive fee contracts. So under fixed price contracts, sellers are legally obligated to complete contract with possible financial damages if they don't. So the risk of non-performance is theoretically on the seller's side. Why is it theoretically on the seller's side? Because buyers need to precisely specify the product or services they want to obtain. They are being procured. So any changes in scope may be accommodated, but with an increase of contract price or time schedule. And also you have to take into account, into consideration, time for necessary negotiation of time and budget change. So any changes in the scope of works result in transferring the risk to the buyer. It's easier to implement warranty and describe it with a fixed price in the fixed price contracts. However, you get it only if the contract is properly executed. You must remember that if it's terminated, you don't get any warranty, but have some different claims. So there are several risks related to this type of contract. First of all, proper definition of a product. If you fail, you don't benefit from any advantages of this type of contract because you don't get the time and budget limitations because you have it either terminated with some claims or you have to change the time and remuneration for this change. If you wish to use incentive fee contract, you have to pick very carefully KPIs to achieve. If you choose the wrong ones, you also fail. The risk of non-performance or exceeding the budget is on the seller's side, but you must remember that you almost always pay a premium for this kind of risks. So if suppliers take these risks, you pay the premium for it. And of course, like I said, it's easier to get a warranty, but Warranty does not replace an SLA agreement. So the statement, I have a fixed price contract with a warranty, so I can require 100% SLA is false. Very often the problem is caused by the software feature itself, the software itself, or some other software you have, and not a bug. So fixed price contracts should be used for waterfall management when the requirements are very well known, clear and fixed, product definition is stable, technology is understood, there are no ambiguous requirements, and the project is short. The second type of contract is cost reimbursable contract, and it involves payments to the seller for all legitimate actual cost for a completed work, plus a fee that is a seller's profit. Cost reimbursable contracts may also include financial incentives for something that the seller exceeds or falls below, like cost schedules or technical performance. The biggest risk for this type of contract is budget exceeding. We have no guarantee, theoretically, we have no guarantee that we obtain the required result for the cost we are ready to spend. So the answer for me is the time and material contracts. These type of contracts resemble also cost reimbursable contracts because they can be left open-ended and may be subject to cost increase. But they also resemble fixed price contracts because some units are fixed priced. So you get a fixed price unit, labor unit, or material rates. They can be preset. And both cost reimbursable and time and materials contracts can manage the budget risks by implementing special tools like budget caps, not to exceed values, budgetary projection, or official notice that we are close to exhaustion some percentage of the budget. So these types of contracts are proper for agile methodology projects when the time schedule is longer, result is not so clear, and also the flow of the project is not so specified upfront. My main practical tip for you: avoid using one type of contract in each situation. You should adjust a template you use to level of knowledge about the project. If you are a startup or build an MVP, you should not require a fixed fee contract because you have your level of knowledge about the project is too low, and you should not pay some premiums for warranty or for covering some other risks that you really do not need because the project is going to be pivoted or changed very soon. So to tell you very briefly, there is no better contract. There are different types of them.
Okay, thanks. Thanks for summarizing and giving practical, actionable tips. Paweł, do you have anything to add here?
I think that presented information by Michał should have already given the listeners the general outlook on how knowing the differences between these payment options may minimize risk. As for myself, I can add maybe two tricks connected with remuneration clauses. One is something that Michał already mentioned, that setting a budget cap. This is a common solution, and this is a mix of ideas coming from the fixed price and time and materials contracts. It is an option in which the client pays for the exact number of hours of the services provided by the vendor, but the parties also set the fixed amount that the client is willing to pay for the vendor services in total. So the vendor acknowledges the fact that he will not receive a remuneration exceeding this fixed amount, and it is his job to accommodate his services within this margin. Even a few days ago, I had an opportunity to draft a purchase order in which the parties determined the hourly rate for one engineer's work. But apart from that, they also set the fixed amount in case there will be a need for his services for 100% number of working hours in 1 month. Maybe this is not a typical budget cap example, but just to show you another options. Basically, budget cap helps the client not to exceed the planned budget. And the second trick will be implementing sprint and the right to verify the services to your contract. Sprint is a term connected with the agile methodology of developing a computer software. And let's say it is a closed period of time, for example, 2 weeks of the cooperation between the client and the vendor. During this time, the vendor provides its services normally, but the software development contract should provide that after this time, after each and every sprint, the client may verify the quality of the services and inform the vendor about any objections. This is what I call a safe harbor in software development contracts. Specified time for the client's complaint, which may be also a possibility to discuss the quality of the services. I believe that a sprint occurrence in connection with the right to verify the services can minimize risk of paying for the poor quality source code.
Okay, and would you say that it's a market standard that the work is verified every sprint?
For the clients that I am working with, this is a standard. We are coming with this proposition on our own idea because I consider that my client is safe with his services and he's not worried about this verification. So I treat it as a standard, and I would also tell the potential clients, if the software house wouldn't appreciate this option or maybe try to omit this, it may be some signal for you that the software house, for some reasons, is not so safe, not so sure about the quality of his code.
Okay. So that is a lot that I think a tech manager could potentially use, especially the budget cap. I think if I were to sign a contract like that, I would probably go for that. Let's move on to the next question then, shall we? And we've touched upon this a little bit, but certainly this is one of the most important parts of any contract, really, that involves money being exchanged for work, let's say. So, terms of payment, what should I expect here, and what is the market standard?
We told you already about budget caps, but what can we tell about terms of payment? Generally, you cannot await that payments are after the work is performed. You should be prepared to pay on a regular, probably monthly basis, even if it's a fixed price contract. You should also accept a prepayment or deposit, especially now in the coronavirus crisis, which threatens companies' liquidity. It may be a fixed amount, or it may increase depending on the average last quarter, for example, of remuneration. Which you should not accept and exceeds market standard is a deposit over 3 months remuneration or additional bank or insurance guarantees. But what is, for example, a standard, market standard, is a guarantee or suretyship of mother company if you are a newly established startup. So this is very briefly about terms of payment. Pavel, anything you want to add from your perspective?
Yeah, I think so. Also saying a few words about deposits and prepayments, because for somehow I consider the client maybe be worried about them, and I do not see why you should be worried about deposit. This is a common market option that appears in everyday life, and based on my experience, deposits are for the bigger projects, longer cooperations, and prepayments go with the smaller ones. But what I see now in my work, that the majority of the contracts that I'm revising have a deposit or prepayment option. So this is a standard for me right now, and I think we all can tell why. Instead of being worried about deposit, you should be rather focused on its content. What Michał said, be careful with the amount. And I agree that exceeding 3 months, for example, is too much. But I can give you 2 advices here. In my opinion, deposits should be embodied in another contract. So I would make you to feel sure and be sure about this, that deposit is established in a separate agreement. Of course, it may be included in a contract, but for me, this is a place where the parties set the rules of the deposit, especially the amount which was set. And the second one, when it comes to deposit, please be aware of the provisions concerning the liquidation of the deposit, because the first and the best scenario is the liquidation of the deposit in a friendly atmosphere after successful cooperation, and then you should expect the deposit to be returned. But the deposit agreement may also establish precisely the events in which the other party, the keeper, has the right to apply the amount of the deposit as a payment. So be careful here, because, for example, in the event that the client delays in any payments, the keeper has any other claim, he can apply the amount as a payment. Pay attention here.
Yeah, I think you touched upon a pretty important general point. A friend once told me that contracts are not signed for when everything goes well. They're actually just signed for when everything actually goes wrong, and to know what happens then. For example, with the deposit in this case. Okay, so Let's move on to something that was already touched upon. And as you said, Paolo, the entire point of a cooperation in terms of software development is to produce some code, and for that code to be then owned by someone. Well, in the end, it should be the client. However, when should this ownership of the IP be transferred, and what are the options here?
Intellectual property ownership may be transferred to other persons by contract, and I see two most common options in terms of deciding the moment of transfer. First choice, which is usually preferred by the client, is that the vendor shall transfer the IP ownership to the source code upon its creation. In other words, as soon as new fragments of the code are created, they are owned by the client. And same from the client's perspective, I would say that the client just wants to secure its budget. Feels safer when the exchange of goods go in that order. First you give me the code, then I give you the money. There may be other motivations, like for example, limited access to the online repository and relying on the vendor's account. Second option, maybe quite opposite, is the one in which the vendor shall transfer the IP ownership to the source code, but upon payment by the client, the whole amount of the fees. And I hope you see the difference here. For example, if the invoicing period is scheduled at the end of each month, the time difference between first and second option may be even a few weeks. Speaking now from the vendor's perspective, I would say that the reasoning goes like this. If the client pays for all performed services, he will own all copyrights. It seems also to be fair and reasonable. So the vendors often, to meet the client expectations, grants the client temporary license to use the source code until payment. It looks like this. Once the source code is available to the client in the online repository, the vendor grants the client a royalty-free license to use the source code. And upon the payment of the fee, the vendor transfers copyrights to the client, and at this moment, the client becomes the sole owner. For me, it seems fair. Also, one thing to remember that from the legal point of view, the first owner of the copyrights are the programmers cooperating with the vendor. So these programmers need to transfer copyrights to the vendor and then the vendor to the client. So there is another condition that you should be aware, and remember that the vendor needs to ensure correct sequence of the IP ownership transfer. Coming back to your questions, Kuba, these are two options. I would go with upon payment option. There is always a place for discussion and I am open to it. If the client insists on upon creation, maybe I would agree, but maybe I will tell deposit should be higher.
Well, certainly I'm glad that this device exists, that you can have this, what sounds to me like a middle option. You only get ownership upon payment, but upon creation, you already get a license that you can do something with the software. It seems like a middle ground, at least from my perspective as, not a lawyer. Okay, with that past us, and of course, if you have any additional questions about this, leave them in the chat and we can get to them during the Q&A session. That is always an option for you. Now let's talk about using open source solutions. They certainly have their advantages in terms of speeding up the project, but from a legal standpoint, let's talk about what are the risks of implementing open source libraries in my solution.
Thank you, Kuba, for this question. It's a very interesting question. First of all, we should answer, why should we use the open source software libraries if it creates risk? Typically, when we hire a software house, we have three types of deliverables. First of all, there is a code individually created for the client under the contract, and it's usually transferred with all the IP rights, most secure option. There are pre-existing IP rights to reusable components, for example, small pieces of code that are not a work themselves, for example, methodologies, frameworks. Software house remains the holder and grants the license to these pieces, and it doesn't create any risk for the client. And finally, there is an open source code under third parties' rights. And you cannot transfer IP rights to this type of code, but you can get the license in the fullest extent possible, but within the scope of original license terms. So if you get individually created code, there is no risk, but First of all, like you said, it's more expensive because you have the code created from scratch. To every piece of code is created from scratch. It's much slower. Using open source libraries speeds up the process even a few times. Open source code is often of a higher quality because it's usually developed by thousands of developers from all over the world with experience in different technologies, and bugs are identified very quickly. The code is constantly reviewed. Open source software is more secure because it's reviewed, and problems are reported problems with security are reported very promptly. So and finally, it's as it's open source, it's easily customizable software. So a developer can easily add any changes, and very often it's a scalable product using open source code. So we really need to use open source code. So how should we avoid risks related to this open source? Firstly, we should check the license terms that come with the project. What should we look for? Consent to commercial use, scope of the license. We should check if the code can be modified. We should check all the additional conditions of open source. And how does it work? For example, MIT, most popular open source license, according to GitHub, which comes with almost half of open source projects, allows anyone to modify, copy the code. Just one has to add a note about copyright and license. You can use the library for any commercial use. You can also modify such library. You can give your own different license to it. So you should use licenses like that to your projects. What you should avoid is copylefts. These are licenses that allow derivative works, but require them to use the same license as original work. For example, if you write some software and release it under GNU GPL license, and then someone else modifies that software and distributes the modified version, the modified version has to be licensed under the same license. So both the original and the new work are open source softwares, and you cannot close the app to anyone. So it obviously limits the commercial use of it. So contractually, you should use open sources, avoid copylefts, and include proper contract clauses. But contractual clauses are not enough. You should also, just to mitigate the risks, you should introduce methodology for marking open source code, include detailed information about the code itself, attach all required files like README or licensed TXT files, and store the open source code in separate repositories. These are my tips. So when I negotiate the contract, I accept open sources in the contracts, but require an open source list as an attachment to each SOW, statement of work or order form. Plus, I require source where to find the license terms. These are my tips.
So from what I'm hearing, the most popular type of license, MIT, is also the safest. So
there are several safe licenses, like Apache license is also quite safe. It's a bit different. It requires slightly different things, but it's also quite safe. But there are also not safe open source copyleft licenses.
yeah, avoid copyleft. I think that's something I will be writing down if I'm ever going to get into the software business from that side. Excellent. Thank you for the detailed answer. And now let's move on to, well, let's talk about ending the contract, and let's talk about what we call the agile exit. I wonder how you would define this agile exit. What are the advantages of exiting the contract in this way, and how can it actually be applied?
Maybe let me start once again. Paweł, can I?
Sure.
Start?
Yeah, no problem.
Like I said at the beginning, we very often we talk about the process itself, but about agile work, about agile projects, but we often forget about contract suspension or contract termination. In my opinion, agile exit means an exit ready to scale the product, to include other teams in further development, to pivot or use source code for changed solutions, to adjust to changed market conditions, in fact. So to make it possible, you should include clauses that allow you to suspend the works or to decrease the seller's team and replace by other external or internal team of your company. But contractual clause is not enough. To be able to implement it in real life, you should secure in your contract that you get from your team, from your supplier, the summary of works with source code indication for the repository. Because from client's perspective, the key is not only the contract, but also technical ability to indicate what has been done under the contract and what IP has been transferred. Contractual clauses must allow you to combine the code with a new code created by new team, external or internal. I also suggest that you should establish exit plan rules, not only implementing a new team, but also mixing or extending teams. And after the cooperation with the current team, current supplier is finished, you should be able to get a commitment to support your registration of IP rights before patent offices, for example, to get the right to exercise personal, non-transferable under some jurisdictions moral copyrights, and also to transfer or to obtain copyrights to new fields of exploitation that are going to be discovered in future. What's really important is also getting back confidential information within given period of time after the ending of the contract. But you must also have a perspective of the software house that has to secure its own interest. The team should have an opportunity to avoid the time on bench, so the time without the project. So termination periods are required, and the longer the project lasts, the longer and the more people you employ, the bigger team you employ, the longer periods are required and are accepted. Paweł, anything to add?
Yeah, I think so. I need to say a few words here because Michał's answer is confirming my belief, which was also said by you, Kuba, that the successful ending of the cooperation, the whole idea of an agile exit, depends just on one thing, your software development contract. If you want to feel safe while making an exit, you have to be focused when signing. And one thing that Michał said was this technical documentation. It is really important, not only the source code, but you should remember, no matter how small the software, it is always good to have it documented. So another thing that I believe you should do is always make sure that the vendor is obligated to produce and maintain the documentation. There are three types of documentation that can be generated for the IT project. It is technical documentation, user documentation, and project documentation. Not coming into details about each of them, but as an example, you should know that the technical documentation is some kind of an instruction that have been created by the programmers who developed the source code. So its goal is to make it easier to understand how the source code works. Then user documentation is a manual designed for the end user to help him learn to use the software. So you think right now how important is not only the source code, but the documentation which is around. And how useful are these types of documentation, especially when ending the contract. I suggest that the technical and user documentation should be transferred to you as often as the source code, and project documentation should be available for you at every time. Also, a few words about termination. Michał said that as longer the project is, you should expect longer periods of termination, which is of course correct because software house needs to balance the bench. Expect also one thing that may come from the software house. The vendor would like to make terminations effective at the end of the calendar month. This is necessary for the software house to keep its bench empty. And this is the standard because software house tries to start projects within starting new month. So please expect that the vendor would like to make termination at the end of the month. And I consider it as a standard and don't find this as inconvenient for the client.
Okay, so I think a lot of thought needs to go into this part of the contract because it is a pivotal moment. And I think the most important thing from a mindset standpoint is to just take into account that and I think both sides need to do this, take into account that no cooperation lasts forever. And at the onset, it would be good to know how the end of the cooperation would actually look. Excellent. So let's move on to the last question that we have planned before we get into Q&A, and something that I'm personally really interested in, force majeure. I would like one of you, if you could, to tell us a little bit about what is force majeure in a few words. When does it apply? But I think the question on everybody's minds is, does force majeure apply now? Does it apply to software development contracts? And does it apply to the COVID-19, let's not call it a crisis, call it a situation?
Okay, maybe I can start now.
Sure.
COVID-19 pandemic occurs and the cancellation of contracts that become a risk, and businesses seem to believe that enforcing the force majeure clause is the easiest way out. And as you said, Kuba, my advice is to be careful with assuming that the COVID-19 pandemic equals force majeure, that terminates your contract and relieves your liability. This may sound interesting that, for example, the Polish law doesn't provide a legal definition of force majeure. It was courts that shaped the definition by giving three conditions: externality, inability to predict, and inability to prevent its effects. All three of these conditions must be satisfied to say that the event may be treated as the force majeure. Something different happens in contract. There is often the definition there, and the force majeure clauses commonly include acts of God, such as floods, fires, earthquakes, as well as other events such as wars or government orders. The force majeure clause often are relieving the party from performing their contractual obligation when circumstances beyond their control arise that make performance impossible. So two things here: one we've got force majeure clause in our contract, one there is not. And in first scenario, before applying the force majeure, you should also remember that probably there are some rules in the contract here, and it occurs very often the first step to notify the other party about inability to perform. And what's more, you must provide evidence that there are no alternative means for performing your obligation. Choosing a software house as an example, I would say that the COVID-19 pandemic is not a force majeure because software house has still the possibility to work remotely, so the performance is possible. This is my opinion, Kuba. I can say, of course, there can be court who will say it, but for my opinion, software houses, it's hard to say if the force majeure makes their work impossible. In the second scenario, then there is no thing in the contract. General rules of the law shall apply. In the end, the applicability of the force majeure would be considered by the court on a case-by-case basis. But I still think that the software house is not enabled to prevent its effects. So good news, bad news. As for today, my opinion is that software house is not most likely to be successful when it gives it a try to invoke the COVID-19 pandemic is a force majeure that makes its performance impossible.
Well, I suppose if you put it that way, and looking at these three conditions, I'm inclined to agree. I've been working mostly remotely for the last few weeks, as have, I think, a lot of the people joining us today. And yeah, we can still get stuff done, like a webinar, for example.
Yeah.
Okay, Michał, anything to add here before we move into Q&A?
Let me slightly disagree. I would maybe add that working in agile team, when you require a cooperation, very tough cooperation sometimes with your client, the COVID pandemic may endanger it. So it may create also possibilities to based on COVID pandemic as a force majeure. So I would defend that there are some cases where you can name COVID pandemic as a force majeure, even if you are a software house. The second thing, just to add, remember there are some places, some jurisdictions where the force majeure concept works only if it's included in the contract, and there are some that require including or defining it in the agreement. So be careful also when drafting your contracts. Just this.
Okay, so in certain jurisdictions, if I look at my contract and the force majeure clause isn't there, that's something to discuss and something to check.
Yes.
Okay, great. Well, that exhausts all of the questions that we had prepared for today, and thank you very, very much for sharing your knowledge here. Now, since we have 14 more minutes left, let's move on to the chat and let's see what questions we've received that we could try and answer. And I can already see one that we could try to address. Thank you, Anna, for the question. And it's about, okay, so we talked about terminating the contract. This one is about how can I secure the rights to my code if I end the contract early? So what changes there?
Okay, so maybe I will start. I was speaking about the agile exit. There are two types of termination of contracts: friendly and unfriendly. These are most common types. Probably, if you end the contract in a friendly way, agile way, or you have it contractually well prepared, there is no problem. This is why I strongly recommend that you should include exit clauses in your contract. Everything what I mentioned before, including clauses allowing you to implement a new team, to extend team, to mix your source code with another code created by some other software team. So these are all the clauses you should secure. And what Pavel mentioned, just to repeat, have an access to repository, get the source code, get the documentation. Pavel, want to add?
Yeah, exactly. That was what I was trying to say. To be honest, we have spoken a little bit about it while talking about this ending. I agree with what Michał said. Also, add one thing. There is also here this topic about transferring the moment of transferring the copyrights, because when it's upon creation, when you exit, okay, we can assume that everything is okay. But when it's upon payment and you are, ending the contract, then you should probably pay or talk with the other party how to manage the topic. So, but in the end, I agree with Michał that it should be a specific place in a contract named exit plan, and there should be settlements, how we deal with this.
Okay, so I suppose the short answer is to have an exit plan and have it well defined. We have two more questions that we could address. Very happy to see them. The next one is from Mark, and he's asking, when the IP rights are transferred, how to impose conditions that the code will not be transferred outside to third parties and that the code will not be resold? So what advice would you give here?
I will start by providing this clause in a contract. I will just take the contract. Also remember about this open sources thing that Michał said, check the licenses of the open sources if they were used, if it will be applicable. And the next thing I will do, I will sit with the manager and the developer, talk about this source code. Has it something inside that is not even possible, not gives us a possibility to resolve it? And if not, then I will provide a clause in a contract.
Okay, Michał, anything from your end?
when the IP is transferred, the supplier is not an owner anymore. So the supplier cannot transfer it once again. Of course, the supplier may transfer the software once again without IP rights. And probably this is the question: how to avoid your software is transferred, resold to somebody else. If I misunderstand it, please correct me. So just to avoid it, you should have also clauses requiring confidential information to be returned immediately after the IP rights are transferred. You should have also the proper flow of the access to repository, to code repository. So if the IP is transferred or the agreement is terminated, you should be able to close the access to the repository as a client. And of course, there are claims. You should maybe have some penalties for breaching NDA and confidential information obligations. So these are clauses, and these are methods I would use.
So from a practical standpoint, what I'm hearing is, once the ownership is actually transferred, I am within my rights to close access to the repository, to the software house, so they no longer can access it.
Yes, this is the difference between IP transfer upon creation and upon payment. When there is a dispute about payment, the client is not an owner of the IP and cannot close it. It's just a licensee. So it may create some problems. The solution is to have the IP secured upon creation transfer, but find or secure software house by a higher deposit. This is my tip.
Okay, great. Thank you for that. And Mark, if you have a follow-up question, I think we might have time to address it as well. If not, let's move on to another question by Marta. And this one, I was curious myself. I suppose it depends on the type of the model of cooperation, but this one is about overtime. So how should I approach overtime in my contract? If the software house developers have to work overtime, how does that affect the conditions of the cooperation?
This question is related to the types of contracts. So this is a threat. I think with time and materials contract or cost reimbursable contracts, where when the budget is, let's say, open-ended, it's a real threat. But we already answered the question how to secure you as a client. Budget caps, not to exceed values, official notices when the budget is exhausted in, let's say, 30%, 50%, and 90%. So these are practical things I often use while drafting MSA, software or service agreements.
Yeah. So what I understand from Michał's opinion, that the client position is to be aware of it, set the budget limit, and try not to accept the overtime from the software house side. But speaking from the software house side, I can say that software house should approach overtime in his contract simply by putting this in this contract, being careful with giving the information about the exact hours of working, notifying client that the 100% of the byte hours are right now full, and they're starting to work in overtime, and probably it will go with higher rates. So as a software house, you should put in your contract things connected with overtime, tell when overtime happens and how it will be burden on the client to pay for it, and be careful with notifying and leaving the proof of that you mentioned your client, you tell your client that the overtime is started.
So as a client, then I should expect just to be informed that my team is now working overtime to meet the deadline. And also you mentioned budget caps. So I should expect to be informed when the 30%, 50%, 90% of the cap has been used up.
Yeah.
Yes, you're right, but sometimes overtime work is just necessary, and you must be aware that you have to await an overtime, especially when you change the scope of the project. Sometimes it's unreasonable approach that the client awaits to be within the budget while changing the scope, but it's a case of good communication and good cooperation rather than contractual. If the cooperation and communication is very open, the parties may get an agreement easily.
Yes, and this good cooperation is brought to you by person like Scrum Master, project owner, team lead, the person who are in constant contact with client, and also this sprint manner. This everything is connected with the agile methodology. So when it comes to the sprints, there is 1 week meeting with the team leader, defining the product backlog, what will happen in a few days. So everything happens in a constant communication between the client and the vendor.
Okay, so I suppose a good and smooth cooperation with a lot of communication can help alleviate a lot of the problems that might arise here. Thank you, and I don't see any additional questions in the chat, and I do care about us finishing on time because some people might have a meeting starting in just 4 minutes from now. So thank you very much for the questions, and of course, thank you, Michał and Paweł, for the answers. And in terms of finishing up and sharing a few final thoughts, this was the Q&A session. Thank you very much for that very helpful slide indeed that I had there. So thank you everyone for joining us during this webinar and this presentation. This was of course only 1 hour. So if you have any additional questions, I will be sending you an email within 24 hours with a replay of this presentation if you want to revisit any parts of it. In terms of who brought you this presentation, if you were ever curious, myself and Paweł, we represent STX Next, and we are Europe's largest Python software house. In short, if you have a software project in mind, we can help define it, design it, deliver it, and of course, develop it. So you can always contact us about that. The address is right on the slide if you would like to reach out to us. And in terms of DSK Legal, I think it's best for Michał to say a few words.
I would add that we secure it what STX delivers, because we are biggest IT law company in Western Poland. We also provide some other legal services related to commercial law, tax law. So we are biggest and most experienced law company in Western Poland.
Okay, thank you. So if you want to learn more about Michał's services, again, the address is right there, and an English version of the site is available if you'd like to explore that. And wow, I think for the first time in history, we have a webinar that is ending before the allotted time. So thank you very much again, Michał and Paweł, for joining us, for sharing your expertise. Thanks a lot to all of our attendees. You were great. Thank you for the questions. And again, look forward to receiving an email from me soon with the replay if you'd like to tell your friends or to explore it again. And that's it. That's all we have for today. So thank you very much.
Thank you very much, guys.
Thank you. Thank you for the invitation. Bye.
Sure, no problem. Bye.